If you have a case against you in Massachusetts Superior Court, that means that a prosecutor has already presented the case to a grand jury. This is a group of 16 to 23 people, and those people are in usually a separate room. You don't have a chance to be heard or present evidence. The prosecutor basically chooses who is called as a witness, what evidence is presented in front of this grand jury. And at the end of the time of the presentation, the grand jury gets to decide, is there enough evidence to indict you? They return what's called a true bill if they find that there's enough evidence. Basically, the prosecutor has to prove that there is probable cause that you committed the crime. And probable cause is a pretty low standard. It means is there some evidence that a reasonable person could see and determine that a crime was committed. But the prosecutor does have to prove each element of the required crime. Now, each crime has a set of elements that are required for proof. And those elements can often be found in model jury instructions, because at the end of the case, the jury will be instructed, these are the elements you have to find beyond a reasonable doubt. Sometimes you can find them in appellate court decisions that have reevaluated cases and charges and said, okay, for this charge, these are the elements that need to be met. And sometimes you just have to look to the statute if neither of those are available. In any case, once the attorney has identified those elements of the crime, in every Superior Court case, we look at the transcript of the grand jury, which tells us what the testimony and exhibits offered were, who testified, what they said, and what the exhibits were that the grand jury actually evaluated. Now, in those cases, we also look to see if the elements of the crime have been met based on what was presented to the grand jury. And if even one element has not been covered, either by mistake or because the element just wasn't violated by the conduct of the client, then we can challenge that indictment. So we could either challenge all of the charges if there's grounds to do so, or even if just one of the charges simply didn't have probable cause for even a single element, then we would file a motion to dismiss for lack of probable cause. Sometimes that's referred to as a McCarthy motion, because there's a case in Superior Court that went up to the appellate courts, Commonwealth versus McCarthy, and the appellate courts determined that there needs to be probable cause for each element of the crime when presented to the grand jury. And if that's not done, then a Superior Court judge can evaluate a motion to dismiss, and if the judge agrees that there was not sufficient probable cause, the judge can dismiss that indictment or those indictments. And so it's a pretty common motion to dismiss, certainly not in every case, but it is probably one of the most, if not the most, common motion to dismiss in Superior Court in Massachusetts state courts. So it's the first thing you look at, because if that's the case, if you have a motion to dismiss for lack of probable cause, you can file that motion before you even wait for discovery or before you conduct the whole investigation. That can nip a whole case in the bud before it creates all of the required anxiety and tasks and work and money that's involved in dealing with the entire case. If that doesn't work, then of course there are other steps that can be done. There's lots of different motions that can be filed. There's multiple kinds of motions to dismiss. There's motions to suppress. There's motions for discovery. There's motions for subpoenas. There is a lot to be done in a criminal case. So this is typically one of the first steps after arraignment and after the grand jury transcripts, or they call it the grand jury minutes, and the exhibits have been turned over to the defense. That's one of the first things that we look at to see if there's a motion to dismiss.